Jules, welcome back to the show. Before the break, we were talking about quite a few interesting stories, but now our topic tonight is about WorkCover, some recent decisions. Nardine, can you give us the facts of a case of Karantzis and Deakin University? It's a 2012 decision, very important.
Yes.
What are the facts?
Well, it was a woman that was working in a cafeteria at Deakin University, and upon finishing her work went through the car park which was maintained by Deakin University, and it was unfortunately attacked by
A stranger.
A stranger. Yes, that's right. And at the first instance at the county court, she sued her employer and the occupier, being Deakin University, but unfortunately due to a prevalent case, the judge at the first instance decided or directed the jury that there was no fault on behalf of the occupier.
John, the case that Nardine's referring to is Mowbray Triangle. It's a very infamous case from South Australia. What are the facts of that case?
Tony, really, the outcome of that case is basically an occupier, person that owns land, has no duty to someone that's on his land that's attacked by a criminal third party.
It's all about foreseeability of risk.
Exactly.
And too remote.
Exactly.
Is that correct?
Exactly.
But what's significant in the South Australian decision is that in South Australia you can't sue an employer for common law damages. So what the lawyers in that case did was try and sue the occupier. But the difference between that case and the case of Karantzis is that they've sued the employer and the occupier. Now, in the first instance, a judge directed the jury that there's no duty of care. Is that correct?
Yes, Tony. It was appealed to the Court of Appeal of the Supreme Court of Victoria.
3 judges.
3 judges, and they came up with a different decision, didn't they, Tony?
Why? What'd they say?
Well, they distinguished Mowbray Triangle. They said in this particular instance, everyone, the occupier and the employer at Deakin University knew that these attacks had been going on. Now, and they knew that this lady and all the other people were parking in this particular car park and walking this particular route.
But it wasn't the usual car park, Nardine. What they did was they barricaded the original car park and they directed them to another car park where there was poor lighting.
That's right.
And also there was reports of someone that was loitering. Is that correct?
That's correct. And even then it was also found that Deakin University had controlled the direction in which to take the car park route. So in that instance, the judges at the Supreme Court thought that, well, the relationship between the employee and the occupier was similar to that between employee and employer.
And John, Deakin University had employed spotless security, correct?
Yes, exactly.
So they've taken precaution. They identified that there was a risk, obviously, because they wouldn't have had security otherwise, correct?
The whole key of the case, Tony, is Deakin knew there was a risk out there, but basically the court found that they didn't do enough to stop injury to the plaintiff in this case.
Okay. Look, some key elements in this case, viewers, was the fact that they redirected employers because the original car park was barricaded. There was also someone that was loitering in the premises, and there's a non-delegable duty of care by the employer, isn't that correct, John?
Exactly, Tony. On the other hand, if the university had provided an extra guard on that alternative route that this lady had to go on, they probably would have discharged their duty, wouldn't they, Tony?
Most likely. But there was issues of lighting and other things, wasn't there?
Of course there was. Yes, there was.
I think it was a pretty good decision, and they distinguished Mowbray Triangle.
Exactly.
Yep.
And this type of case, we come up, and this type of problem we have time and time again, don't we, Tony?
We do.
Where we have a victim in on someone's land, and basically the landowner or the employer turns around and says, how was I supposed to know that that type of injury would occur?
That's exactly right.
Usually our response then is, the plaintiff lawyer is, well, if you were on notice about that injury, that's how you would have known. That's
exactly right. Look, there's a very interesting case decided just recently, as early as this year. Ian Bainbridge, Aka Santa Claus, and James Jacobine and Lou Zig, Custodian Proprietary Limited.
It's a very novel decision, Tony.
What are the facts of that, Nardine?
Well, it seems the plaintiff in this matter at the time was working as Father Christmas, had finished working and was going back to get changed out of his Christmas outfit, and was unfortunately attacked by a teenage boy. And he sued his employer and the shopping centre for damages.
Okay, let's get this right. Same principles apply. A third party's attacked Father Christmas.
On
correct?
an occupier's land, yes.
But Father Christmas lost in this case.
In this case, there was no Christmas present for Father Christmas in this case, Tony.
Why, John? What did he lose? What was the issue there?
The Court of Appeal, again, this went to the Court of Appeal. Although, sorry, before I get to that, at first instance, Tony, Judge Smith of the County Court of Victoria awarded him $80,000
So he won his case in the first instance.
He won his case.
And that was for pain and suffering, wasn't it?
Yes.
Okay.
But then it was appealed. Basically, and the Court of Appeal found that, again, Modbury Triangle rules. That how on earth would the owners of the shopping centre know that this attack would occur?
They said it wasn't reasonably foreseeable.
Exactly.
It was just so far-fetched and fanciful. Is that correct, Nardine?
That's
Isn't that what the
correct.
court
That's
said?
correct. And they even said in their commentary in the judgment that it was the court was not prepared to impose such a duty, but even then it was a policy concern as to how they could have imposed consequences on the shopping centre in these instances.
In fact, the court said it was extraordinary that someone as generally well loved as Father Christmas, out of a blue, would be attacked in the way that he was.
Look, that's all. I have to admit, I've got an issue with the policy considerations of the court, Tony. They've basically concluded that the old floodgate scenario, Tony, that basically if we let this case go through, well, then everyone can sue for, being a victim. At the same time, we're talking about...
But this can be distinguished from the last case, can't it, Nardine? Because what you had in the last case was a pathway that had been barricaded. They gave you an alternative route, which was created by the employer. The lighting was very, very poor.
That's right.
There was a known stranger loitering in the area. So the facts were a lot stronger in Karantzis' case, isn't that correct?
That's right, because we say the court at the time said it was reasonable foreseeable that an attack could have happened in the instance.
And John, also, Father Christmas was just going to the toilet to get changed. I mean, that could have been you or me or Nardine going to the toilet to get changed.
It's a tough case, Tony, and unfortunately, Father Christmas lost.
We've got to go to a sponsors break, viewers, so please stay tuned. And after the break, we'll be doing a very interesting decision of Kochak.